There is a storm on the horizon, a time of hardship and pain. The battle has been won, but the war against the machines rages on. This is John Connor. There is no fate but what we make. That was not from a recent ruling by the DC Circuit, but its spirit from Terminator Salvation may have been. The court ruled that an AI program cannot be an author under copyright laws. Is this a victory for humanity in our ongoing war against the machines? Or is it a simple application of longstanding precedent? We'll discuss that, plus crisscrossing the American West from the 10th Circuit this week on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, March 26, 2025, and we have a tale of two Dans today. Dan Nepper, who is our General Counsel at the Institute for Justice and is a regular guest here on Short Circuit, and also a first-timer, Dan Nelson, who's been at IJ for a little while, but he's on here for his first appearance. So we will get to Dan Nepper in a little bit about the war against the machines. Now, Dan, last time he was on the show, had a beautiful Christmas sweater with a dinosaur on it. This week, his fashion choice is not as important for the show, but I will say that he has a visual, and I think Dan Nelson will also have a visual for both of their cases. So if you are an audio listener to Short Circuit, which is great, this is a YouTube version this week, and it might be a week that you later go to the YouTube to see the visuals if you're interested in seeing them. And if you're a YouTuber, well, then hello. So we're going to go, as I said, to Dan Nepper in a moment. But first, to Dan Nelson. So Dan, among other things he does at IJ, he recently co-authored an article that is be published in the coming months about the history of Section 1983. That is the Civil Rights Act of 1871, a law that we have talked about many times on the show and that we at IJ depend on for much of our civil rights work. Dan has discovered some history that has not been really discussed in this way before, that may shed some light on some ongoing scholarship about this law's origins deep in the midst of Reconstruction. So, Dan, give us a little teaser about that.
Yeah, so thanks so much. So I co-authored a paper with our colleague Patrick Yakima, who's a senior attorney here at IJ, and he litigates a lot on Section 1983 cases. And as a lot of you probably know, Section 1983 is a civil rights statute where you can sue state officials who violate your constitutional rights. And there's a doctrine that the Supreme Court created called qualified immunity, and it often immunizes state officers even if they violate your rights. And Patrick and I unearthed this original clause in the 1871 language of the statute that discounts, that displaces, and just completely rejects qualified immunity. Now, the statute back then said every person shall be liable, notwithstanding any contrary state law. And this notwithstanding clause matters because, according to the Supreme Court, qualified immunity is a doctrine at state common law. And so this clause just rejects that. Now, there has been recent scholarship on the existence of this clause. What our article really focuses on is the omission. This clause was, for previously unknown reasons, dropped from Section 1983, just 3 years after the statute was enacted. And the current kind of consensus is that that omission seems to walk back Section 1983's original rejection of qualified immunity. And we just detail the history of this clause and explain that everyone back then understood that you could remove these ubiquitous notwithstanding clauses. I mean, they were everywhere in old statutes. You could remove these and it wouldn't change the substance of the statute at all. And so today, Section 1983 still displaces qualified immunity. And this paper is going to be forthcoming on the Harvard Journal of Law and Public Policy, so we're really excited about it.
Yeah, and if viewers and listeners are interested, they can see that draft that we'll put a link in the show notes to. reading it, I learned all kinds of stuff I had no idea about how notwithstanding clauses used to be used and how they drafted statutes in the 18th and 19th century. I mean, it's really fascinating stuff that is actually really relevant to current litigation. So we will look forward to talking about that, I'm sure, in the future on Short Circuit. But now we are going to Dan Neppert. Now, Dan, I made this out to be pretty bleak what humanity is facing, and that the DC Circuit has rejected this latest thrust from artificial intelligence. But I believe you may have a kind of a more happy story about the machines and humanity getting together, and say this is kind of a little less like, this is just kind of growing pains, maybe a little less like Terminator, a little more like Star Trek.
Indeed. Thanks, Anthony. I'll be looking at Thaler versus Perlmutter. It's a D.C. Circuit Court of Appeals case from last week. It's a 3-judge panel with Judge Millett authoring the opinion. It was Judges Millett and Wilkins and Senior Judge Rogers. But you're right. Like, the best part of this opinion is as they get later on, as they start talking about policy and whether machines can respond to certain types of incentives and whatnot, they compare the artificial intelligence in this case with Data from Star Trek, and say your Data might be capable of many things, but he's not capable of good poetry. And they said, Felis Catus is your taxonomic nomenclature, an endothermic quadruped carnivorous by nature. That's truly terrible, Data. Truly terrible.
ChatGPT can get some good poetry, I'll say. I tried it out.
But I believe you. So, all right. So we were looking at I was excited when this case decision came down last week. I emailed Anthony. I emailed you almost right away. We've got a Court of Appeals case on artificial intelligence. Finally, we're going to get some clarity on this topic. We're all really excited about. Read all about it, and we don't get a whole lot. That's the long and short of it.
But it's really interesting. The guy who brought this case, the actual human, he has a plan that seems pretty interesting.
Yeah, and some reading about it. So is this a test case? Like, what was he really trying to accomplish here? So the background is we have Dr. Stephen Thaler, who's a computer scientist, and he created an AI machine called the Creativity Machine, and he set the Creativity Machine to art, and I believe that's the technical term. And the Creativity Machine made a picture entitled A Recent Entrance to Paradise. For our radio listeners out there, the picture is a set of a rather old-looking set of train tracks that are heading into what looks like a bridge tunnel. So you can see light on the opposite side of this tunnel, and it's got sunlight basking on the other side, and there's just so much foliage. There's foliage everywhere. Lots of green and lots of purpley vines. Like this is the art. This is the art. And I looked around. I tried to find an art critic to provide their thoughts on the merits of this, and so far have been stymied. For some reason, no one wants to take an opinion on whether the Creativity Machine is creating good art. And so with Dr. Thaler,
what's your view? I mean, it kind of reminded me of some of that, like sports art you get in bars. I mean, I wasn't super impressed by it, but it's not terrible.
I was going more with like if you're out there and you see like the folks that are doing like the spray can art with like the wolves howling at the moon and that kind of stuff, right? That was where I was headed. Sure. But it maybe not for me, but you might like it. And so Dr. Thaler, then having created this, or not the Creativity Machine, having created this masterpiece, Dr. Thaler submitted a copyright registration application for the art to the U.S. Copyright Office, and this ends up being very critical. Listed the Creativity Machine as the work's sole author. He listed himself as the owner of the copyright. The Copyright Office denied the application because the Copyright Office has a human authorship requirement. Work must be authored, so says the office, in the first instance by a human being in order to be eligible. Dr. Thaler took it through the administrative process and then to the district court, which affirmed the Copyright Office's determination. And we're now on to the D.C. Circuit Court of Appeals. And against that backdrop, we finally get to learn something about the legality of something to do with generative AI. And what we learned is not much. That we learned we were reminded of some good data poetry, but the DC Circuit Court has made a relatively straightforward, non-dramatic statutory interpretation that says no copyrights are available for work that was entirely created by AI. I bet there are different outcomes if work isn't entirely created by AI, and there's like some human element in it, some part human, some part AI. But that's not our case here, and so we'll wait and decide that issue later.
But also, there's this twist right along the way. So he says that I don't know all the steps in getting a copyright, but basically it's an administrative process, and he applies and he says the only author, which is different than owner, as you said, is the creativity machine.
Correct.
And then it's denied. And they said, are you really? So really, you're asking for the creativity machine to be the author. He says, yes, not me, just the creativity machine. And so it goes like 2 steps up. And then, but when he gets to district court, it seems like he starts hedging his bets. And he says, well, I could be the author if it's, that I just use the creativity machine to do that. But then they said, well, you waived that, buddy.
Too late. Yeah. And so we'll talk about it a little bit. I could talk about it now. The Copyright Office has provided, so the legal answer to this question, Andy, is you're right? It was waived. Then the Court of Appeals spent very little time on it. So did the district court. It's just because it was brought up too late. Then they didn't spend any time on it. The Copyright Office has, for a couple of years, provided guidance in its thoughts. We'll call it guidance in its thoughts on how it evaluates submissions for copyrights that are supplemented to some of or created to some extent by artificial intelligence. Right? And what they have said is they said you got to look at the fundamental, the essential nature of what is. So if it's a song, song has got to be the music. If it's poetry, it's got to be the words. These have to be created by a human. And it has said mere prompts to AI probably not going to be enough. And they have denied some. They've denied some applications that were submitted by AI. When there is a combination, so some human, some AI, the Copyright Office does its best. And so, like an example of this is there was an an artist used AI to create images. The human operator arranged those images in Photoshop and did some enhancements and so on, and then ran that through, as I understand it, through something to make it a little bit like higher resolution or something along those lines. And the Copyright Office said you get a copyright for that the work you did in Photoshop, but only for what you did in Photoshop, right? And so the Copyright Office is wrestling with some tough questions, right, and trying to figure out how much of this is how much of a AI supplemented work gets copyright protection and under what circumstances. I think the court is going to say not only is that question not in front of us, but that is a question for Congress. And I kind of think in this instance that's the right answer. These are really complicated, all kinds of different things. It's hard to imagine the right set of facts and circumstances coming before courts to allow them to fashion this type of rule. These are big policy decisions. The Constitution empowers Congress to make rules related to copyright and patents, and I think that is where this should get straightened out.
So you mentioned the Constitution. One other wrinkle, it seems, is going on in the background is the Copyright Office. They argued, look, the statute doesn't allow for a computer program to be an author. Right. But then they had a backup argument the court didn't get to, that constitutionally it has to be a human who is an author based on the clause in Article 1, Section 8 about Congress's power to give a copyright. Do you see that playing a role in the future, or is that kind of a just a side note because everyone understands that we're not going to start giving copyrights to computer programs?
So
or are we?
I think it is. I think it is more of a side note. But there's probably some facts. I can think of it. There was a case not that long ago that has a great nickname called the monkey selfie case, which was
we've talked about that case before. Yeah.
which is a copyright case that I don't know if you could guess involves a monkey taking a selfie. Right, and that case was at the Ninth Circuit, and the Ninth Circuit dispatched it on standing grounds, but standing grounds within the Copyright Act, and because there's just so much good statutory language and the way that it's put together to really have a basis that for a copyright under the Copyright Act, the author has to be a human. And so maybe there are avenues around that, but that's been the framework for animals so far, and now for robot overlords.
I love how the court went in this case. The court went through all the reasons has to be a human, and at one point it says that they refer to a widow or widower for how your copyright would pass to someone else, and they say machines aren't widows or widowers, or have children is another reference.
Yeah, it's just, so there are the Copyright Act gives certain rights to the owners, and all of those rights can only be exercised. So says the court, as you gave an example, all of those rights can really only be exercised by humans. But then in the very next paragraph, Anthony, it says, oh, and by the way, the copyright also says machines aren't authors, and it says parts of machines are computer programs. Like, you kind of could have just started right there, right? Like,
it seemed a little beating a dead horse, I gotta say. Like they were trying to cut off every avenue in case maybe the same plaintiff, maybe someone else came back and tried this again.
One of the things that did strike me is the analysis, notwithstanding the little bit of the policy talk, which is a question for Congress and so on, but the analysis on this was brief. Like the Dr. Thaler's opposing arguments fail, period. It was just kind of to the core. We're not gonna mess around with this. We're not gonna open up alternative ways for this to get interpreted. We're gonna take this straight down the statute. We're gonna get rid of it because the tough cases are coming. And I kind of got the sense that this panel was delighted to not have those tough cases yet. Like they had a very clean way to read this consistent with precedent, consistent with the statute, and they put it aside and said we'll deal with those times when there are humans involved later.
Yeah, Dan Nelson, you see this as not a tough case, also?
I think this is a pretty easy case, and I think look, the second we all started using ChatGPT, you knew this case was coming. I'm a little surprised. I mean, I'm with you guys, but I'm a little surprised that, this guy didn't try to make the argument that he ultimately waived, which was that, he himself was the author. I don't know if that was intentional, like if he really wanted to try to pioneer this case where AI can itself copyright things. But I thought that was really interesting. And, we'll see where Congress grows from here. But I agree with Dan. I mean, this is really one of those instances where the court's just like, look, like the copyright says what it says, and we're in a new era in a lot of ways, but let's just let Congress take care of it from here.
Also, as far as his motivation, or maybe other computer scientists' motivation, I kind of see. I mean, the actual try here seemed like it's very narrow, targeted. Let's see if it works. Obviously, a test case. And it didn't work in this case, but there's kind of two other bigger questions. One is the one you were just talking about, Dan Nepper, which is that what if you use AI to create things, and what if you're the creator of the AI? Is that different than you create the AI and then some other user goes and using it, right? Like the former one, I could see a good argument for you being then the author or the owner of that work. But then the bigger one, which perhaps this computer scientist is into, perhaps not, but I'm sure there are out there, is artificial intelligence programs themselves having some kind of rights, right? This is the data question, the Star Trek question. And this is one way you could have a right, which is a copyright. Another way you just talked about is standing if you get into court. And if we do, I mean, people are still split on, the Turing test and if there are machines that are going to pass it or have already passed it. But if we do actually start having something that we plausibly would say that is like a person, this artificial intelligence, are they going to be able to do things like the creativity machine wasn't able to do here? And that's really a question I'm sure that these three judges were very happy they did not have to address.
No, and I thought one of the things they'd agree. I thought one of the things that the court did that was setting a foundation, right? Reminding you reminding you what this is all about is saying, like, the copyright is not supposed to be for we don't have it to help the author. We have the copyright because we want it to be difficult. We want to grant this short-term monopoly because somebody who works hard to create something should be able to enjoy the value of it without other people stealing it from them cheaply or creating it cheaply on the second go around. And so the incentive here is for everybody else to go and create something uniquely valuable on their own, right? Like that's why the Copyright Act works, and it's the economics of it. And they say machines don't work like that. Like, they don't respond to those incentives, at least not yet, right? And so, like, as Dr. Thiss says, like, this is going to, if you don't allow AI to get a copyright, people who do AI are going to lack the incentive to create fabulous new things. And the court was like, no, humans are still motivated. Right, and so we think we'll see how that plays out. But also, Congress has some time to figure this piece out. These questions are big and beyond what we have to deal with today, and so we'll let them deal with it. In your first example that you gave, Anthony, I had imagined it slightly different, which was, let's say I create an AI machine, and I train it solely on my own stuff. Right, so I have an AI machine that is going to produce things that are only that are only based off of things that I have all of the rights to.
Your own personal watercolor.
Yes. And what would the output of that AI have to be mine? Would the copyrights because I created the machine, and everything that the machine does is based off what I learned. And I'm not. I mean, you would think there's a good argument for it. The way the Copyright Office is looking at it right now, though, they're looking at it, I think, on who's putting the words on the paper. Like, where does that come from? Because if it's not coming from a human, it doesn't count. And so, I think all of these things are examples. Your examples, this are potentially ways at which you're going to see, these debates get played out over time.
Yeah, because of course, no feasible AI program is going to be, as you just said. It's instead going to have like everything on the internet.
Right.
Which, of course, one person has not authored. No. Yeah. Well, we will follow this, and I'm sure this is not the first of this kind of case we're going to discuss. So we are now going to move out west. Now, I worked and lived in the Mountain West for a short time. I grew up way out west on the West Coast. And so I've always been a little confused about this checkerboard pattern of ownership you get out there. I learned about it, I remember, a little bit in social studies and the railroads. They kind of gave land to some people, but not others. But I never really understood it much until I read this very interesting case that Dan Nelson is going to tell us about.
Yeah, this case is wild. I mean, when I first looked at it, it looked like just kind of a Wild West trespass case. But there's just the checkerboard really makes things so interesting. And this checkerboard you're talking about covers millions of acres in the West. So this had pretty big implications. But really, this trespass dispute got pretty nasty. It was between a rancher and some hunters. And it's not like the hunters were like on this guy's private property, like shooting his cattle or something like that. They actually weren't even walking or hunting on his public grounds. What they were doing was they were, while walking to hunt onto public grounds, they were doing what's called corner crossing. And it's this really weird form of getting to public lands to hunt that really only exists in the West. And so just like imagine a checkerboard where, you've got like red and black squares. Every other square is red, every other square is black. And imagine the government owns all the red squares and a private party, in this case the rancher, owns all the black squares. And all the red public squares, the government squares, are hunting grounds for hunters. But the problem is, it's kind of hard to get to these squares because you've got all the black ones, all the private squares. And so what hunters do is they go to the very, very, very corner of a public square, and where the two public squares are connected diagonally, the hunters walk across to continue hunting. Now, this poses a problem because while you're not actually walking on any private property whatsoever, you are invading the private airspace of the black squares of the
Right, because
rancher's
by
property.
definition, there's a point there. Like literally, like go back to high
it's
school
a point.
geometry. There
Exactly.
is a Euclidean point, and your body is not that thin, so you're going to have to go over private land to get to this public square.
Yeah, and like I actually thought about this for maybe a little, like more than a second, which is a little embarrassing. I'm like, okay, like if I take a checker like on a checkerboard and I move it diagonally, like it's round, it's going over onto these black squares, and like, I mean, I would contend I'm not as round as a checker, but like even if I'm walking diagonally, I'm still crossing over their land, my shoulders, my pack, whatever else. And so this is where the dispute really gets going, when this rancher finds out these hunters are doing this. And really it starts off by this rancher sending out his employees to kind of tell these hunters, hey, stop, you can't do this, and kind of yelling at them. That doesn't really work. So then what does the rancher do next? He puts no trespassing signs over and like around this like little tiny marker that denotes exactly where the corner is, so these hunters know where to step over and not, step on any private grounds. And by doing that, the hunters can't step over. They can't crawl under these signs and the chains and stuff that this guy put up. And so what they do is they have to hold on to these trespassing signs and like swivel around their legs around, so that they're still not touching private property, but they are touching the signs. And the rancher points this out. And so then the next time they go out hunting, they get an A-frame ladder. I'm not kidding. They get an A-frame metal ladder. And this is like out in the middle of nowhere, so I don't know how far they had to carry this thing. But they get an A-frame ladder to climb over the no trespassing signs and then walk back down, so that they never walk on private property. But
And and these square, like the at least here, they haven't put fences up or anything.
No.
It really is just a stake kind of in the middle of nowhere, and you just kind of have to know. They had, I think, GPS devices to know exactly what was public and private.
Yeah, I think it's called Onyx X Hunt or something like that. I've actually used the app before for one of our IJ cases. It's super, super accurate. It's all like GPS coordinates. So like these hunters have it down probably to like the centimeter. So
Yeah.
and the facts, at least in the record, are like, yeah, they weren't stepping on private grounds at all. The most that they were doing at that one point was touching those trespassing signs to do that swivel from one public square to another public square. So anyway, this is like a whole drawn out thing. The rancher actually ends up convincing the local prosecutor to charge them for criminal trespass. This actually goes to a jury trial and they're acquitted. And then later he's like, look, I'm going to sue you in civil trespass, and I'm going to seek $9 million. We could talk more about like where that number came from. Because they're not doing any damage to the property, so it's interesting that it's $9 million. And he's saying, look, it doesn't matter if you're not touching my land, you're still violating my private airspace. That's a trespass under Wyoming state law, just plain and simple. And despite the suit that the lower court rules for the hunters, this goes up to the 10th Circuit. There's really sort of like two issues. One is like, is this in fact a civil trespass? And the 10th Circuit actually says, yes, this is under Wyoming state law, which is where you answer this question. This is a civil trespass. You don't just own the land. You don't own the ground. You own what's under the ground, and you own what's above the ground.
Yeah, there's all this talk about how the Romans said you own everything to the sky and how things were before airplanes.
Oh, yeah, this goes back centuries. Yeah, and even today, like, yeah, airplanes can, like, fly over you, but you do own the low level airspace. By the way, this makes total sense because, like, I mean, people could, like, put up bridges, like, if they could, over your property,
or
if
drones,
you didn't have this.
as we've
or
discussed
drones.
before.
Yes. So this is like a legitimate thing, and so the 10th Circuit says, yeah, this is a civil trespass, but then there's issue 2, which is, okay, even if we have a civil trespass, does federal law preempt liability for civil trespass for these hunters? And the 10th Circuit says yes. And it says that because of this old 1885 statute that Congress enacted because of the confusion and troubles with all these different squares. And and basically
Unlawful Enclosures Act.
Yes, the UIA, and it's probably best to just quote it here, but the UIA declares all enclosures of any public lands to be unlawful. And then to that end, it says no person by force, threats, intimidation, or by any fencing or enclosing or any other unlawful means shall prevent or obstruct free passage or transit over or through the public lands. And so the hunters are saying, look, by you not letting us do this corner crossing, you are violating this act, which says you can't obstruct free passage. And
which those chains definitely seem like they're doing.
Yeah. And the court's like, look, it says enclosures or fencing, so it doesn't just have to be fencing, even if you're just like, kind of like yelling at them to not like cross onto a public land. Like, that's still a violation of the statute. And, the whole purpose was because back then in 1885, you had the squares back then, and apparently all these cattle barons were like closing off the public squares next to the private squares that they owned, and this was causing a problem. And Congress said, look, we got to fix this. We got to provide this free passage. And so essentially, like, at bottom, what the 10th Circuit says is like, look, this is a civil trespass, but you enforcing this is a nuisance against, like, under the federal statute, under the UIA, this constitutes a nuisance, and essentially the hunters are allowed to abate it by corner crossing. So it's just a very interesting, it's not an easement. It's not something like where the hunters could like build a road. It's just allowing them to abate what the 10th Circuit characterizes as a nuisance, given that the UIA says the rancher can't do this.
So I guess thinking of that, if the rancher says, okay, well, I'm going to take away the stakes and the chain, but then we go back to what we started with where, okay, you do the corner crossing, but you do actually go over the airspace of a tiny bit of the corner. At that point, the rancher isn't doing a nuisance. So would they then have a trespass action? Because the court also says, like you just said, this is not creating a easement.
Yeah, I mean, so the court basically says, like, look, the UIA is not providing any, there's no, like, necessity doctrine here. We're not providing an implied access.
Right, like someone who's landlocked within someone else's land usually.
Yeah, like, this
right
isn't,
there.
Exactly. That's not what the UIA is doing. It's just like, if you are not letting these hunters access these public lands, essentially what you were saying is no one can access these public lands, really, but the rancher, because he owns, the adjoining private lots. And so that in and of itself is the nuisance that needs to be abated. And it doesn't really matter if there's fencing or not. It's just like the fact that you're trying to obstruct that. You're trying to obstruct that free passage. That itself is the nuisance.
Can I ask a question?
Yeah, go for it.
How'd they get the elk out?
I never thought about that.
Right?
I don't know. Yeah, I don't know. So this actually raises. Can I just to follow up on that?
Yeah.
So I actually listened to the oral argument on this, and it's interesting because it's like, okay, you're not allowing an implied easement by necessity. Like, the court's not saying there's a right of access per se, but it's like, okay, you're obviously offering more than just that little needle, but like what if hunters want to take their like vehicles, like their trucks and stuff? They don't want to do all this walking. Like, do you have to open the width for this corner crossing? Like, what if you have the one judge was I forgot who it was, but he said like, what if you have disabled hunters in wheelchairs? Like, do you have to widen the corner crossing? And I think this case poses some really difficult questions, really on both ends, by the way, because either you're kind of like allowing these hunters to access private land in ways where like I don't really know where the line is, but then on the other hand, if you're ruling for the rancher, you're basically just saying like these millions of acres of public land, these public squares that are completely landlocked, arguably given Congress's short-sightedness, and we can talk about that too, but these million acres are like foreclosed now. Like it's really tricky, and it's just a jumbled mess of, centuries of case law that the 10th Circuit was trying to like sift through and figure out to draw a rule.
Maybe because I'm sure some of our viewers and listeners are just like, why is the land like this? Like, why would anyone set up this public and private checkerboard thing in the first place? I give a little of that history, because even reading, like I'm reading the case and knowing the history and knowing a little bit anyway, it still is kind of bizarre how they Congress did that and then they just left it there.
Yeah, I mean, so the short of it is Congress was trying to incentivize westward expansion, westward development, and their idea was they were very excited about this. If you look at like the congressional record and stuff, so their thinking was, oh, look, if we sell every other private square to like railroads and stuff, what they're going to do is they're going to develop it, and we'll probably get access roads and all this other development, and economy is going to happen. And that's going to drive up the prices of the public squares that we owned. And then we can sell them for money. That never happened, because it turns out this is all just desert land. And once you find out...
it happened elsewhere, right? Like, say, parts of Montana or the Dakotas where there were cities built up.
Exactly.
But a lot of it, especially here in southern Wyoming, it like just no one lives there.
Yeah, exactly. And it's just like, once you find the desert plots that have and don't have water, it's like, well, all the private developers go to the ones with water and with other resources, and then you leave. No one wants the public ones. And so eventually when Congress was like, well, we can't sell them, they're not worth anything, we can't even sell them for like pennies, they just said, well, we'll just have them for hunting grounds. And, that's what they're used for today.
Yeah, and they hand out permits to hunt in
right.
them. I mean, these hunters, no allegation they did anything wrong, right?
Right. Yeah, I do want to talk about the damages for a little bit too.
Yeah.
So, I mean, when I saw $9 million, I'm like, what in the world? I mean, like, why $9 million? And the hunters alleged, like in their briefing, that the $9 million actually comes basically from the fact that the rancher was like calculating the value of his land and then also the value of like the public land, kind of like the fact that he was the only one in effect at that time that could access these public squares kind of like elevated the value of his land like 25 to 30%, according to one of his experts. And so the hunters were sort of like, look, the hunters were sort of accusing the rancher of like trying to just acquire all this public land for himself. And the rancher was just saying, look, like, no, it's just like you can't just like trespass on my land. I don't care if you're stepping on it or not. I still have air rights. So there was that interesting back and forth, sort of trading barbs a little bit.
That seems to be more a question of like actual ownership rights, right? So if like nobody can access the land, then the value of my land goes up X or whatever it is, probably inflated anyway. But if people can access the land, then that value disappears. But that's not like what these three guys actually did, because they didn't cause that. That's just a legal question. They're trotting across this land. If he won, I mean, he probably would just get nominal damages, I would think.
Yeah, I think that's right. Absolutely.
How is it? Other question I have: how is this in federal court? Is it just diversity because these hunters aren't from Wyoming, or?
Yeah, I mean, there were some federal questions. I mean, obviously you had the UIA involved, and there was some takings litigation too.
But at bottom, it's just a state trespass civil action, right?
Yeah, I think. Well, I mean, I think there was I guess there was diversity because the hunters actually, now that you bring this up, they weren't from Wyoming, if I remember correctly. There were 4 hunters. I'm pretty sure of that. Yeah. But actually, that makes me think of one other thing, which was like when I was reading this, I was like, how is this not a takings? Like, can Congress just pass a statute and say like, well, like people of the public have access to your land now, and you don't get any compensation? And the court actually does wrestle with this, and kind of ultimately, it's like the court concludes, look, like even if maybe this could constitute a taking, this access, this like a right to corner cross, pre-existed the rancher's ownership of the land. So when he acquired the land, there was sort of just like this pre-existing limitation, which I think is a little interesting. I was almost like, like, does the rancher not get the rights from, the prior owner of the land? I guess according to the court, he doesn't. But I just thought that was really interesting that, takings was implicated and the court did have to wrestle with that.
That seems to me in a way kind of bringing back the access by necessity point that the court elsewhere says that this isn't, but it kind of has to be, it seems, because if you divvy up land this way to the whoever bought it, back whenever, and the understanding is that the public can still, that's public land. In some way, you have to understand that the public is going to be able to corner cross.
Yeah.
And so it is an easement, and we don't call it an easement, but it's there. And so so this is not this court's ruling is not a taking, because you never had the right to make these people not be able to corner cross in the first place.
Right. Yeah. And I think, I kept coming away thinking this really just kind of feels like an easement. I understand it's not, and I think the court was really trying to emphasize, like, look, we're not saying you have a permanent right of access or that you could build a road. I think they were really trying to focus on this idea, I think probably in order to try to reconcile this mess of case law, this jumbled mess, according to the court. Not only that, and just to try to give it like a really narrow ruling, to try to just say, look, we're just letting you guys abate a nuisance. And I think this leaves some line drawing questions down the road that, the court was cognizant of, especially during oral argument, but I think they're saving that for another day.
Well, we will save further exploration of corner crossing for another day, but I would love to get back to it. It seems there's a few cases. There's other ones from the Ninth Circuit that discuss it. Oh, and that reminds, before we close, there is one point I wanted to address, which is they say, so I hadn't seen this before, but the 10th Circuit was at one point carved out of the 8th Circuit, just like the 11th Circuit was carved out of the 5th Circuit at 1981, right? So the 11th Circuit is the youngest geographical circuit. It was the old 5th Circuit was like huge, kind of like the 9th Circuit today, and it was basically all the South. And so then they carved the 11th, or almost all the South, the 11th out of it. But then it says that it cites this old 8th Circuit case, which is actually geographically now where the 10th Circuit is. But then they say we're not bound by that case because our own precedent is we're not bound by these old 8th Circuit cases. But the 11th Circuit has said exactly the opposite about old 5th Circuit cases. And, it's probably, I guess they each have the power to do their own thing for whatever reason. But it's kind of interesting that they don't feel they have to follow that.
I was puzzled as well. I'm like, this is literally the same. These are the same states we're talking about. This is the same geographic area. I was very puzzled myself. And I feel like there's got to be some interesting history there. But the 10th Circuit has long said that we're not bound by this old 8th Circuit. I just thought that was really interesting. I agree with you.
Yeah, and by the way, it is a lot older. So I said 1981 for the 11th Circuit. The 10th Circuit it was created in 1929.
Oh wow!
So, and this really is old cases we're talking about. But when we're talking about Western property rights, there are some old cases out there
for sure.
So, yes. Well, thank you, Dan. That was fascinating. And Dan Nepper, yours was fascinating as well. We will get back to both of these issues, as I was saying, in the future. But for now, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.